Well, for those of you that don't already know me, my name is Lee Hills. I'm a partner at the law firm of Mayo in Baxter. And as Sharon mentioned, we are corporate members of PARTA and provide to its members a complimentary a help and advice line, telephone, email, or when we return to some sort of semblance of normality, even in person. But Sharon has details of that and can provide details to anyone that needs any assistance or has any questions after this morning's session. I've worked with and for the travel sector for about 30 years now. And so this morning, although we're focusing on some of the issues which have come to light and are of perhaps the greatest concern to businesses operating in the sector following the outbreak of the pandemic, I'm also going to be touching upon some of those issues which I come across from a legal perspective, representing the sector, and which are probably as much relevance now as they then were. So in the 20 minutes or so that we have, we're going to have a canter through some of these issues, and all I can really do at this point in the time I've got is to provide you with some pointers of areas that, if you're not already doing so, it might be a good time to think about. Now, I've used this analogy before, and it's not one that any of us would wish, but I've heard it said, and have used this example myself, that downturns and recessions are a little bit like pit stops in a Formula One race. The cars, being companies, are all whizzing around the track, trying to beat each other. And occasionally a downturn, a recession, in this case caused by a pandemic, comes along, and cars all slow down, the businesses slow down and pull into the pit stop. And what can make a difference to those companies that come out of the pit stop first, but ultimately may end up winning the race, are some of the adjustments that are made to the business during the downtime. And so it is, even though I'm sure none of us wish that we where we are, it is an opportunity, and if you're not already doing so, it's worth using the time to put some of these measures in place. What you're going to see me doing, I think Sharon can see me doing, is the wonders of modern technology have defeated us slightly. So if you see me scratching my nose, I'm not actually bidding through a secret online auction that's showing my other screen, but it'll be a little sign to Sharon, who's controlling our PowerPoints this morning, to move them forward. So thank you, Sharon. That's the next slide. We can move that forward. Terrific. Now, this is just a little reminder of, irrespective of the awful times we're experiencing, but even in better times, some of the reasons why it's good to make sure that your business, and from my perspective, from the legal side of things, is put into the best order that it can be to prevent complaints, which can ultimately lead to claims for compensation and a host of other awful things happening. Just looking at some of these facts and figures that come from pre-COVID, you can see that those of you who may be members of ABTA itself receives some 22,000 complaints from customers each year, half of which lead to arbitration referrals. And of those 11,000, ABTA making an excess year in, year out, some £2 million worth of awards against its members. That's something which is obviously good to avoid. There is an inherent risk, particularly in the litigious society in which we have come to live and operate, of claims for accidents and injuries. And Tour operators are particularly susceptible to these because, unlike most other businesses, they can and do accept what we call vicarious liability for the acts of their suppliers who have perhaps performed some of the individual component parts of the holiday, irrespective of whether they were the cause of those or not. Now, those, you will be insured, I'm sure, public liability insurance, but irrespective, like any type of insurance, it's going to lead to increased premiums, it's going to eat into any excess that you've agreed on your insurance policy, and ultimately, and we're seeing this now from conversations I'm having with professional colleagues and referrers who also work for this sector, but within the insurance industry, the market is hardening and premiums are increasing, and with reduced income, ultimately businesses, tour operators could become uninsurable. So again, another reason just to take note of some of the matters we're going to be touching upon later. Thank you, Sharon. Again, just touching on a few other causes, misrepresentation. This is going to be relevant when we come to look at the information that you have but are continuing to share with your customers and potential customers relating to your product. Misrepresentation as a cause of action in civil claims. It's a standalone action that your customers could bring against you in the county courts, but also, when we look at this shortly, it can lead to a criminal wrong, prosecutions by trading standards, which in the current regime carry unlimited fines in the magistrates' court. And just for the travel industry alone, and again, this is pre-COVID, leading to some in excess of 8,000 complaints a year to trading standards, some of which may lead to criminal prosecutions and fines. And then, of course, what is difficult to measure, but is nevertheless equally important, is the adverse publicity, because you know, we all depend on our reputations, and with the growth of social media and the majority of perhaps bookings being made over the internet, some of the review sites, touched on there, Google, Trustpilot, etc., are important. And if you're getting poor reviews through not managing your processes and procedures, that's going to have an impact down the line. Thank you, Sharon. Lastly, something that not everyone is necessarily aware of, but I think is of importance. I've certainly come across it before when acting for travel businesses, is the Advertising Standards Authority. That's a consumer-facing complaints body that will investigate misleading adverts that are placed. Adverts in this case perhaps being the holidays, the products that you're selling. Again, so 11,000 complaints a year, increase, perhaps understandably, as a result of online advertising. But the consequences of an adverse ruling against you by the ASA, following a complaint by perhaps one of your customers, but it also, I have seen, I've got to say, competitors of businesses making mischievous complaints to the ASA, will result in a public ruling that will be open to the public to see. Ultimately, your adverts can be required to be amended or removed. There's additional costs that arises from that. And finally, if non-compliance continues, trading standards can get involved and can bring a criminal prosecution. So it's probably just stating the obvious, but there's a few things there for you to bear in mind as to why now may be a good time to just do a review of some of your processes and procedures that we're going to come on to next. Sharon, thank you. From the 1st of July 2018, the England and Wales introduced and enacted the European Package Travel Directive, the new one that replaced the regulations that have been in force since 1992. Much of it is fairly similar, but there are some changes that have come from it. But of course, COVID's now hit, and the lawyers and the courts and the regulators really have yet to get their teeth into the interpretation of these regulations and for them to be properly tested. But I'm going to touch upon some of the areas that are similar to the pre-2018 regulations, but are still new, and perhaps matters that you should think about, particularly in the context of the changing landscape that has come from the pandemic. Now, specifically within the regulations, Regulation 6 refers to your brochures and online content, the products that you are displaying to your customers in the hope of gaining their business. One of the things you do need to be careful of is that what you say in your product information will form an integral part of the contract. Now, pre-2018, the lawyers would refer to online content, brochure content, as being an implied warranty. And there were arguments as to whether or not that warranty formed part of the contract and therefore an obligation that you would have to fulfill and be bound by, or whether it's simply advertising puff. Now, that hasn't yet been tested by the courts since 2018, but what you may have, the words and the images that you may have used to describe your product, what you're able to offer, what you are offering, the destination, may very well and probably will be different now than it was this time last year because of the restrictions that have been imposed upon us. So I mention that now because it is useful, if you haven't already done so, to review what you are promising to your customers in your content and what you can actually deliver. Thank you, Sharon. Again, I'm sure most of you, certainly on the tour operating side, will be familiar with some of the requirements that are imposed upon you in terms of what information you need to provide to your customers prior to the booking. Now, I've just bullet pointed some of these in this next slide, but the information is contained within Schedule 1 to the regulations, but include the main characteristics of the travel service. That is, the location that they're going to, what the main features of the accommodation are, the travel and transport, what you are saying that you will provide to the customer. Now, you're not warrantying, of course, that the sun's going to shine or that there are going to be dolphins swimming in the bay or whatever, but those main characteristics you are bound by. And so once again, I think in the current landscape, it is worth reviewing what you have said and what product information you've designed if it were designed prior to the outbreak of the pandemic. I also mention information about the suitability for customers' needs. Now, the regulations do refer to essentially people with mobility issues, but upon specific request by the customer, if they ask you about the suitability of the product, the destination, what it is for their needs, then you're required to provide it. And again, this is untested, uncharted waters, but I can see it that it is conceivable that if you have a customer that perhaps had a pre-existing condition or susceptibility to perhaps more serious illness from COVID, and they were to ask you about the destination, the product, in relation to that, you may need to provide it. It's uncharted waters, but I can see it I can see it as certainly a possibility, and therefore I think it is important, and we'll again come to this later on in the talk, to ensure that your information about your product is as up to date as possible. Thank you, Sharon. Again, just touching upon, we're looking at areas of obligations and areas of liability. Again, you're going to be familiar with this, I'm sure, if you're a tour operator. And it isn't a great deal different to what the pre-1st of July 18 regulations said. But liability can arise through the performance of the travel services. If there's a lack of conformity, i.e. you are not delivering what you have promised to deliver, so it's important for you to think, what are you promising I'm going to deliver? That can result in a price reduction, or if it amounts to a very significant failure on your part, ultimately it could lead to a refund and compensation. Thank you, Sharon. I touched upon this earlier when we were talking about areas of potential exposure. There is a standalone set of regulations that you may be familiar with, that trading standards enforce, unfair trading regulations 2008, that apply to any consumer facing businesses, but again provides an area of risk, I suppose, to you for either providing false or misleading information, again, as to the main characteristics of the holiday, or omitting material information. And this may include what's happening on the ground. Thank you, Sharon. And this is enforced by trading standards, can lead to criminal liability, unlimited fines, but equally defences, not only to civil claims, but ultimately, if you had the misfortune of facing a criminal prosecution, due diligence is a defence. So evidence checks, procedures, documentation, trail, audits that Colin will touch upon are important to not only have conducted, but to have to hand. So worthwhile, again, just getting your house in order now, if not for now, then for the future when people start travelling again. Thanks, Sharon. I'm going to skip across this next slide because it sort of overlaps a bit with what Colin's going to talk about in terms of auditing. But again, it reinforces the importance of what Colin will talk about. With pre-season and ongoing auditing of the main characteristics, products of your product. Thank you, Sharon. This is important, and it goes back to what I was saying very early on in the talk about liability for brochure online content and the positive consequences of failing to do that generally, but particularly now. If there are changes that have arisen to what the main characteristics of your products are, or what actually is available and what you're suggesting is available to customers, then I think you need to have in place measures and processes for updating and amending these, issuing erratas to agents or the suppliers as and when they arise. Again, I mentioned this, it's not something that a lot of people always think about, but if you have telesales operatives or agents that are operating from scripts, then ensure their product information is up to date, whether it's hard copy or online. And again, there is no legal precedent for this, but I think a lot of businesses have been issuing a general sort of COVID caveat on their website, stating perhaps the obvious, as Basil Fawlty might say, but that things are different, that things are going to change, and in perhaps reinforcing the need for customers to, where possible, make their own inquiries or draw them to sites where information can be obtained about what is happening at the destination in the resort. Thank you, Sharon. Booking conditions is something that I have banged on about to clients, not from a self-serving perspective, but for their own benefit for many years, but it's equally important now. It's worth using the time because I think many businesses that I've come across, particularly tour operators, surprisingly still haven't updated their booking conditions to ensure that they reflect the additional obligations that are imposed upon them by the new regulations. They're not providing key notices, key rights notices, as they're required to do by law. And, you know, potentially are accepting greater potential liability and responsibility than they need to through their booking conditions, because, for example, they may be selling products or combining products that would not fall within the category of a package, but nevertheless haven't changed their T's and C's and are contractually accepting responsibility even though they wouldn't do so under the regulations. Excursions has been a long-standing issue for us as lawyers, where we've seen that an excursion is sold perhaps in resort or separately to the package, but nevertheless through the T's and C's, the company has accepted the same liability and responsibility for those as they would for the rest of the package, and it's not necessary. And again, I think worth reinforcing, particularly at the moment, that it's local standards by which you are judged in respect of any claims or complaints, and not UK standards. And very often, maybe less so at the moment, I don't know, but they're going to be lower than in resort. Thank you, Sharon. This again is a real bugbear of mine, and I've heard many businesses saying that they wish they had reviewed their contracts with their external suppliers, particularly the providers of products, transport accommodation providers, or their DMCs or ground agents. And it is important now. We've seen and read about how many hotels have not been refunding, or have tour operators in scenarios where the regulations have required the operator to refund customers. And I appreciate that there's only so much you can do through contracts, and indeed they require the suppliers to accept your contracts, but they should be reviewed, and the obligations that you have, if you are an operator, to your customers, particularly in refunds, you should try to mirror those in the obligations that your suppliers have to you, to put you in the best position for securing refunds in the event of a situation such as this either becoming exacerbated or continuing for the foreseeable future. And indeed, where suppliers perhaps are DMCs or ground agents, make sure that there is, if not a contractual obligation on their part, then a working arrangement for them to keep you updated and appraised of what is actually happening in resort. Thank you, Sharon, who's flashing at me that time is marching on. So if I speak quicker, it's not the 3 cups of coffee I've already drunk. Okay. Again, this links through to your content, but also the arrangements that you have with overseas suppliers. I think that if information and photographs, for example, that you may have obtained from them are displayed in your product information are no longer relevant, then not only do they need to be changed, but any agreements that you have with suppliers. And I'm banging on about tour operators here, but of course I appreciate that the audience doesn't necessarily comprise totally of tour operators. If there are suppliers who themselves have subcontractors for part of the supply process, what I'm talking about applies equally to them for the benefit of them. But there should be warranties and indemnities from suppliers or subcontractors that if they mess up, they don't provide you with the information that they're contracted to provide, and that results in claims against you by your customers, then the contracts include indemnity in your favour, and possibly, cash being king, possession being 9/10 of the law, retention clauses on the part of the party paying the contract, perhaps to hold on to the money and pay a little bit further down the line. So if things go wrong, you've got the money and you have the opportunity to retain that pending resolution of any dispute. I've thrown in there again force majeure clauses. Force majeure is something which, a word expression we've heard bandied around quite a bit lately, and I think is going to lead to a lot of litigation over the next couple of years or so. The legal draftsmen have updated their clauses, standard template clauses, to ensure that there is specific reference to pandemics. And it's important that you, if you're using force majeure clauses, if you look at nothing else, you ensure that they are up to date and cover you and protect you as best they can, but particularly for pandemics. And law and jurisdiction clauses, most lawyers will tell you that it's much, much easier for you to, if you have to get involved with the courts, to do so in England than to have to do so overseas. So they're just some key areas that I think are worth looking at in any contracts. Thank you, Sharon. Again, we touched upon this, but just to reinforce what obligations tour operators particularly have, there is an enhanced obligation to provide appropriate and prompt assistance to travellers in difficulties overseas, and so with the the heightened anxiety that's arisen as a result of the pandemic, I think it's important to ensure that you have those systems in place and here have points of reference in each of your destinations, either directly or through your local agents, with consulars, health authorities, and the ability to provide help and advice on the ground if it's necessary. You can charge for it in certain circumstances, but that's very often something which doesn't involve a lot of money and is argued about further down the line, but is important to comply with your obligations, but also to show that you're taking it seriously, and to perhaps improve those reviews, which are going to be all important and might provide you with the edge next year. Thank you, Sharon. And again, these are areas which we touched upon, but linked through to the last slide. Training, anybody that has employed resort staff or through local agents, make sure they are up to date and aware and familiar with the concerns, the worries that your customers in the UK, if it is the UK, may have relating to COVID. And my experience having acted for tour operators and a whole range of travel sector businesses for, so 30 years, big and small, is that those that have the best track record are those that are able to nip complaints in the bud, in resort, or immediately upon return to the UK. There's one operator, large operator I act for, who have one of the best records in the industry. And that was because if they hadn't resolved issues in resort, then as soon as the customer landed, they were on the phone to them. And before they got to the grubby, greedy lawyers to start bringing claims. So again, an area of the business which I think is worth reviewing now in the COVID world in which we're presently operating, but will also put you in good stead for the future. Thank you, Sharon. Time is ticking on. I said this was going to be a really quick canter through, and it is. Stating the obvious again, if you take the time now, time that many of us very often don't have when we're busy, rushing around that racetrack trying to beat each other, not only, I think, may it help you leave that pit stop first and ultimately pass the checkered flag first, it's going to help you with, as I said there, improve product quality, definitely lower overheads, customer retention, which is king, and ultimately an improved bottom line. So that's pretty much all I was going to talk about in the 20 minutes I've got. There will be an opportunity for some questions at the end, and I know Sharon has a few questions that have been submitted by our audience. My contact details are there. Irrespective of the complimentary advice line that we operate for Parser, in any event, if anything arises that you think of subsequently, do feel free to drop me an email or give me a call on the direct dial, and I'll be very pleased to help you. And now passing across to Colin.
Right, hello everyone. Thanks very much, Lee, and also to Sharon and Chris for having me present at this seminar. So I'm speaking on behalf of Tranquilico, which is my business, and also Sanderson Phillips, and we both work in the health, safety, crisis management sector with partner memberships and other organizations. So Sharon, next slide, please. I'm going to talk very quickly about our services, just for those of you who don't know us, a little bit about the health and safety importance, and very briefly legal responsibilities, because Lee has covered a lot of that already. And then I want to cover risk management and in particular COVID-19 protocols at the end. Okay, so that's our services as organizations. We offer safety management systems, audit protocols, training, electronic self-assessment systems, physical inspections as well, and then a plethora of crisis management services to tour operators. Next one, Sharon. That's some of our clients. Just so you know, we work with large tour operators, small tour operators, DMCs, travel agent companies, and a plethora of suppliers across the travel sector. Okay, next slide. And just something I'm particularly proud of, actually, from a Tranquilico point of view, we do work also with some premier football clubs, notably Liverpool, Chelsea, and also with England rugby travel. We worked on the Rugby World Cup, and also on the Lions tour in South Africa next summer. Okay, next slide. So Lee has talked about your responsibility, and I particularly wanted to itemize the sort of corporate responsibility from a criminal negligence point of view. And I think it's important to point that out to not only tour operators in the UK, but also suppliers overseas, so that they're aware of the responsibility that UK tour operators face. They're under the Package Travel Directive. Tour operators are responsible for the negligent acts of their suppliers overseas, and that's all European tour operators. But in many countries, it's only, or European countries, this only amounts to then civil liability, so that the tour operator just faces fines. That's particular in Germany, for example, where a company will only get fined if somebody dies overseas on one of their holidays. However, in the UK and in several other European countries, this was also enacted into criminal law, which means the tour operator can face criminal investigation and potential prison sentence for things that go wrong and seriously impact from a fatality point of view with customers traveling on their holidays. And I believe although we're leaving the European Union, the government have indicated that they won't lower any consumer protection. So it's likely that that implication of criminal responsibility still lie on UK tour operators. Next slide. Just to show you, actually, it is alive and well. There are a number of high-profile companies who've had corporate manslaughter investigations, notably Club Med, Thomson, or TUI as they're known, also a smaller tour operator here in the UK called OLL. And actually, Thomas Cook faced potentially 2 corporate manslaughter investigations with their 2 serious incidents in Corfu in Egypt, although they managed to evade an investigation because of some of the processes that they had in place. Okay, next slide, please. Just so that you're aware, safety, as Lee has said, is something that you can not only you have to focus on as part of your risk management and take proper due diligence and care and attention, but you can actually make a sort of marketing benefit from it, if you like. And I always point out school travel companies in the UK. So their target market are children traveling without their parents. Parents are obviously concerned about the safety of their children traveling without them. And these companies make a huge thing about safety on their websites and in their information. So here you've got codes of practice, safety management, managing safety on the trips. Here are risk assessment documents and so on. I'm not saying you need to do that, but next slide, please, Sharon. What you can do is, if you're a business, is create your own safety logo, make your own, here are some examples of what some of our clients have done. They've created a safety logo, which they use to pass on their safety message to their clients through their website, through customer information, but also to their suppliers when they do auditing and due diligence inspections with their suppliers. And it enforces a sort of mark of quality to a tour operator. So it's a bit like a sustainability logo. You can use it. You can make one up. Here's, again, as I said, examples of some of our clients. Next slide. So I'm going to cover very quickly some of the main issues that you need to consider. Aviation safety is something that for tour operators, less of an issue if you're using large international airlines that operate ex-UK. They're all members of what is termed IOSA, which is IATA's Operational Safety Assessment. And if they are on the IOSA registry, and you can Google that, you can find a list of all the airlines that are part of that, then you know that they're reaching the highest levels of aviation safety, and literally you don't need to do anything further. However, next slide, Sharon. If you as an operator or even as a DMC or a supplier overseas are contracting non-IOSA airlines, which are airlines that sit below that sort of level of international aviation safety, then actually it can be beholden to you to do some checks on them and some reasonable due diligence before you use them. And I have a plethora of UK tour operators who do that for the small number of non-IOSA airlines they use in their programs. Okay, next slide. Transport safety, that's probably the biggest issue because most tour operators, most DMCs will, as soon as clients arrive into a destination, pop them onto a coach, a minibus, or a private car or taxi. And actually that's proven to be one of the greatest risks to passengers overseas. The government here in the UK conduct a road safety campaign every year for travellers overseas because they know it's one of the biggest killers of the travelling public. And so here again, it's beholding to you as a tour operator and also you as a DMC if you're subcontracting to do some due diligence on any suppliers that you use, making sure they've got seat belts, that they do maintenance, they monitor the driver's hours. They also, particularly now, we've seen an increase in drivers who are taking mobile phone calls and clutching a mobile phone to their ear whilst driving along a motorway or a mountain road, which is something you want to avoid. Next slide, please. Accommodation safety, again, another big area of focus. As you can see here, fire does kill. So you want to be ensuring that any supplier, any hotel that you contract or through a DMC, again, there's some due diligence being carried out to ensure that they're operating to what we term good practice guidance. You're not asking people to reach UK regulation, as Leah said, but you are asking them to have good practice health and safety within their accommodation. Next slide, please. So just to give you some examples, these are two properties that I went and physically inspected relatively recently. So to show you, locked and blocked fire escapes are still an issue even now. So here is one in Romania, 5-star hotel actually, and one in the French Alps, which was a 4-star property. Both cases, their fire escapes were blocked by chairs and mattresses. And these are things that you need to be ensuring don't happen. Obviously, you can't do physical inspections everywhere. You can do a sample of physical inspections of your product, but by doing self-assessments and raising the issue of unlocked, unblocked fire escapes, at least you're bringing that to attention and covering yourself from a due diligence point of view. Next slide, please. Balcony safety, again, is another issue. Again, local standards apply, which means that actually, for example, I know in some countries, particularly in Asia, balcony heights don't necessarily have to reach a meter. In the UK, the standard is 1.1 meter for any new property. But actually good practice guidance, what we push for is a meter high and also no step-up allurement. So here you can see this balcony with a child is actually a climbing frame it's created. Although it's a beautiful balcony, from a safety perspective, it's not ideal. And just to bring something to your attention here is that one of my clients is actually currently dealing with a balcony fatality from last summer, where the UK coroner has requested all the documentation that they hold relating to the height of the balcony, any due diligence checks they've taken, any safety assessments, and they have to provide that to the coroner in time for the inquest. So again, that's worth bearing in mind if you're a UK tour operator or indeed a DMC contracting on behalf of a tour operator. Next slide, please. Pool safety, another issue to consider. As you can see, swimming pool designs can cause fatalities. So again, it's part of accommodation safety. You look at all the various aspects of a hotel, be it gas, glass, lifts, pools, fire safety, and balconies. Everything needs to be checked from a due diligence perspective. Next slide, please. Oh, actually, and glass. So that is just even the simplest thing of having stickers on patio windows can save you an enormous amount of money. Here's an example of £100,000 paid out to a holidaymaker because they walked through a glass patio door that didn't have any stickers, and because of that, they lost their claim and they had to pay out a significant proportion of money to the holidaymaker. Next slide, please. It's worth mentioning, this one I've put in more just for a bit of fun for you, but this is also tour operators are responsible for the safe delivery of food and water. And whilst we don't believe it's feasible for tour operators to go and do hygiene checks in every property that they use, perhaps the big tour operators can, the likes of TUI, for example, and Jet2 Holidays may have the capability of doing that, but most small to medium-sized tour operators don't have the infrastructure. So from a food safety point of view, what you should be doing as part of your due diligence is asking and checking to make sure the supplier has food safety management systems in place, Legionella prevention systems in place, and that staff are trained in food safety and food hygiene for the delivery of safe food and water to customers. What's interesting is tour operators often monitor hygiene using this sort of data, which is what is called subjective traveler's diarrhea. So it's basically people who've ticked the box to say that they've had stomach-related illness lasting 24 hours or more whilst traveling to these destinations. And that gives you an underlying feeling about the hygiene in any given destination and where potentially you probably should focus your hygiene attention. Next slide, please. And on that, it can be costly. I used to work for My Travel many years ago before it was purchased by Thomas Cook. And you can see there, we paid out £10,000 just to one couple who fell ill because they were staying in an all-inclusive hotel. We couldn't defend this claim on the basis that they'd eaten anywhere else. And sadly, that's what it cost us. Now, it's paid by insurance, but obviously, as Lee said, that ultimately affects your bottom line because you end up paying more in premiums and then for having to pass the cost on to the holidaymaker. Next slide, please. And then just to make you aware, if you haven't seen this, quite a famous case, First Choice Holidays have paid out the largest amount for a hygiene-related illness claim of almost £250,000. So you can imagine the impact that had on their bottom line. And again, an all-inclusive resort, difficult to defend, and sadly, the client was awarded a large sum of money. Next slide, please. Activity safety. So again, that's something Lee touched on. If you include any what we term high-risk activities or excursions within your package offering, then it's beholden to you to do some form of a safety check on the supplier. If it's sold in resort locally, then actually depending on how you sell that and depending on what your terms and conditions are, you can then remove yourselves from the liability of that activity and excursion provider. So again, it's worth taking legal advice on how you do that. Next slide, please. So what you need to do, basically in a sort of quick canter, is if you're a tour operator or even if you're a DMC, create your safety management system. So have your policies and procedures, your documentation all in order. Make health and safety a sort of an agenda point on any board or senior management meeting, because it shows you then taking safety seriously and it's documented, and it gives an opportunity for anybody within the organization to raise the safety issue right up to board and senior management. Set a budget line. So if your budget is only £50, have a budget. If your budget is £1,000, have a budget. Again, it shows in your accounts that you take health and safety seriously and that you even apportion money to your due diligence. And then make somebody responsible for it. If nobody's responsible for safety within an organization, then nothing gets done. So it's only if you make somebody responsible for ensuring the delivery of your safety management system does actually work. And as I mentioned before, you can create a soft safety brand to kind of get some marketing benefit from any money that you do spend on due diligence. Risk assess your suppliers. And again, now most people, most tour operators and even DMCs do a mixture of self-assessment and physical checks. And for physical checks, you can set yourself a comfortable percentage for that. You can do 5% of your suppliers, you can do 10% of your suppliers, but it's a bit form of quality control. So if you're doing self-assessment where the supplier is filling something out for you, for legal due diligence, then you can go and check on that if you're going out to resort or staff are traveling to see the suppliers for contracting purposes or for familiar trips or familiarization trips or whatever it may be. And then ensure staff and agents act as in the eyes of your company. So escalate any issues to you that they feel might affect and to take action. And advise your customers to think safely. Give them safety information on your website and pre-departure information. Next slide, please. So there's the benefits to your business. You can read those very quickly. I think even for a supplier overseas, for a DMC, and for a tour operator, all those benefits do come out from having a good safety management system in place. Next slide, please. So I'm going to finish off with my last 5 minutes, a bit about COVID-19, because it's the hot topic of the moment. Ourselves, along with Sanderson Phillips, we've prepared some good practice guidance, which we're giving out free to tour operators, travel agents, and destination management companies. And they cover accommodation, transport, aviation, marine, activity and excursions. That's a good base level for you if you wish to send those out to your key suppliers so that they have some idea of the standards that, or the guidance and the standards that you're expecting them to achieve in relation to hygiene with COVID-19. Next slide, please. On top of that, we have the ability now to send out assessments for COVID-19 of your suppliers. Sanderson Phillips have an accommodation self-assessment, both a simple basic one and also an enhanced self-assessment. And we, along with that, have supporting assessments for transportation, non-IOSA aviation, marine, small cruise boats, day boats, so on, and any activity suppliers, generally the higher risk activity suppliers, so you can check those out as well. Next slide, please. And then finally, is there any hotelier particularly who wants to basically prove to their tour operator clients and also to their customers that they are meeting international good practice in terms of COVID safety, they can now go for accreditation. And ourselves and Sanderson Phillips work with Global Secure Accreditation. It's a bit like going for an ISO certification, but it is fairly onerous, and you have to prove and provide documentary evidence that you're meeting the standards. But if you do that, then you will be awarded by SFJ Awards within the Certificate of International Good Practice. It's valid for a year, and obviously that gives a tremendous comfort to your tour operator clients, travel agent clients, and ultimately to your end consumer, the customer. Next slide, please. That's basically it. So I did very quickly because I tried to catch up on the time as Lee overran. But if you've got some questions, I've noticed there's one from David Kavan, and hopefully I've answered that through my presentation. And I'm now going to pass to Lee, who I think has got a question that he needs to respond to.
Yes, thanks, Colin. That was excellent. Yeah, David sent in a couple of questions, I think. have a quick look at, if you don't mind me sharing these.
Yeah, go for it, Lee.
Okay, some clients have already rebooked twice following forced postponement of their original arrangements. Patients, particularly with the Southeast Asia region, is wearing thin, especially when some suppliers are intent on offering credit notes rather than refunds. Am I right in thinking if clients book through a tour operator, the package Travel Act still requires operators to make cash refund irrespective of whether monies have been received back from the supplier, and there is a time frame for action after have issued their own guidance to some operators, and but obviously not out to members. So unfortunately, David, the answer in short is yes. If you have sold by design or by chance a package which is regulated by the 2018 Package Travel Link Travel Arrangements regulations, then in circumstances such as we've experienced arising from COVID, where travel to the destination or the destination itself it's been not possible to deliver a significant proportion of the product, then the customer arising from these new regulations is entitled to cancel the holiday without charge and request a full refund without compensation because of the force majeure that's arisen, but you are required to provide a refund within 14 days, irrespective of whether or not your suppliers have refunded you. And that sort of, again, brings me back to one of the areas I touched upon in my short presentation about suppliers' agreements, accepting and appreciating that where you contract with your suppliers, they may not wish to contract on your terms. Even if they do, there may be issues arising from your ability to, should you fall out with them, enforce that contract and require them to pay money back to you should the contract provide for it. But it reinforces the point for the need to, first of all, to have those contracts in place where possible, because that's going to put you in a good position. And secondly, again, I know this isn't possible or practical necessarily, but I think it's going to be something that certainly UK tour operators are going to be thinking about very hard going forward when you make your payments to them. Because cash is king, possession is 9/10 of the law, and the longer that it's possible to hang on to payments, should a situation arise where a refund is required, it's going to put you in a better position of having that cash to refund to your customers rather than having to be chasing your suppliers for reimbursement, if that reimbursement is provided for within the contract. So I hope that sort of answers the question, not necessarily the answer you would like. The next second part of this is David saying equally, what's the legal view of an Asian national airline saying flight refunds only considered if the flight is cancelled, could be 48 hours or less to pre-departure. Clients can't obtain pre-required visas for travel because of continued border closures and would be denied boarding even if it operated, but due to the insufficient documentation. Well, again, it's sort of, as far as Asian airlines are concerned, the rules are, the protection is perhaps not quite as strong as it would be if you're dealing with airlines, EU airlines, or those to which the denied boarding regs would apply, as far as you're concerned. But as I understand the question to read, I think apart from you having in place whatever procedures, protocols, contractual arrangements, booking arrangements you can with your airline, it probably isn't going to make too much difference if the borders are closed, your customers can't travel anyway because they're going to be banging on your door for a refund. It puts you back in the same situation, irrespective of where the airline is, which airline it is, of having to ultimately chase the airline for that money. Are there any other
So,
questions?
so there is a question for Colin. So what system do you have in place to ensure hotels have continued with their agreed health and safety policies, especially regarding COVID? Oh, I think you're on mute, Colin.
Yeah, sorry. Hi there, Sharon. Well, I hope that's kind of covered that with the presentation at the end, covering the COVID assessments. Our current, both Sanderson Phillips and Tranquilico, our normal safety assessments don't cover COVID. So we've actually prepared separate COVID assessments for tour operators to use. Obviously, they can do their own thing, or ultimately they can come to us and we can do that for them. There is a cost implication, but a lot of tour operators who are looking to restart programs imminently are going ahead and assessing their suppliers for COVID preparedness. And I suspect Lee would probably say, from a legal point of view, that's probably good due diligence.
Absolutely.
And then obviously for hotels, then they have the option of going that bit further. Obviously, each country has also its own system as well. We're not saying that they don't have to do that. What we're saying is this is another tool for them to use if they wish to prove that they are COVID safe for customers. And I showed one of the certificates, which actually is for Rocco Forte hotels. They're putting all of their hotels that are open through that process because they want to be able to use it from a marketing perspective, but also to give comfort to their customers that they have absolutely everything in place for their safety and security.
Awesome.
So can I just chip in, Bridget, because there's a thought that just has come to mind that may or may not be of some help, but is relevant to David's first question about customers that have, had to have their holidays cancelled and rebooked and cancelled. I don't know whether this is of relevance or not, and I'm not. It's a situation which has arisen for me anyway through clients fairly recently, but where bookings had to be cancelled. What I would loosely describe as refund credit notes were offered and accepted by customers, although some tour operators who have entered into such an arrangement with customers, I don't think have necessarily complied with the guidance, certainly issued by ABTA, as to what that refund credit note should and shouldn't contain to ensure that it is financially protected by ABTA, where ABTA is involved, but nevertheless have received a refund credit note, a voucher, probably wouldn't be financially protected, and have then looked to, or are looking to use that voucher refund credit note prior to the expiry to rebook another holiday, which is great, sort of. The issue then has arisen is, well, look, if they don't, as they're entitled to, ask for the cash refund prior to the expiry of the RCN, use the RCN or voucher to book another trip, and then for reasons unrelated to COVID, personal reasons, Auntie Flo's not very well or whatever, I need to cancel my holiday, and that booking is subject to the usual cancellation terms, which hopefully you have in your booking T's and C's. Do I have to refund the original cash, or can I refund in the method by which this subsequent booking was paid, namely a voucher? Now, I said at the outset that a lot of these issues have come up for the first time as a result of this awful situation we're in and are untested. But the view that I took, and I've had this confirmed by prosecuting trading standards authorities with specialist insight to the travel sector, their view also is that you would not be obliged to refund cash for a second booking utilised through an RCN or voucher, but you would refund, if you're obliged to do so, 50% deposit, whatever it might be, by way of a voucher. Now, that's untested, but it's worth just bearing in mind where cash is king. But it does very much. It does also depend on the wording of the voucher credit note, any terms and conditions which apply to the issuing and use of that. But food for thought.
Awesome. I think we don't have any more questions, but if you guys have any more questions, I'll be sending through a follow-up email and including Lee and Colin's email addresses in there so you can get in touch with them directly. This webinar as well will also be available afterwards if you want to refer back to it, and I will send you a PDF of the presentation as well for your reference. But just another reminder for any of our party members out there, you do have access to these benefits from Mayo and Baxter, Tranquilico and Sanderson Phillips. And if you want more information, I can send that through to you. But thank you, Lee and Colin, for joining us this morning. Thank you for everyone who has attended. I hope you found it a really useful session. And we'll catch up with everybody again, hopefully when this is all over.
Okay.
Thank you. Cheerio. Thanks very much. Bye-bye.
Bye, everyone.
Bye.